Well, good afternoon. Here we are in the last breakout session. Then we just have the panel discussion after this. You know, how many were here 2 years ago? You remember what happened in the panel discussion? I think it was a fire alarm or something, and so we didn't get very far into it. It was like, okay, that's the end of the conference, so we'll see how it works today. I feel a little silly wearing a microphone in here because I don't need it, but we need it for the recording that we're doing, so that's why that's happening. So I hope my voice isn't too loud. So this is what I call the toolbox. Now, how many of you have heard David Hodgins do his presentation on discipline here? Okay, most of you have. This is another presentation on discipline. And it's the same law and it's the same things, and you know, I know what David says and it's all good stuff. This is an effort to try to make it a little bit simpler to understand. A little bit, what I try to give you in the next hour and a half is a framework for thinking about special education discipline and a terminology, a little vocabulary, because I think that helps. And so that's what we're going to talk about. So this is the intro to the toolbox. Now let me see who else here. How many of you are campus administrators? Principal or assistant? AP? Okay. Who else? Anybody else? Campus administrators? Okay. Special ed directors? Okay. Right. Or assistant? Okay. People that are here as parents, just as parents, in other words, because a lot of the other people are teachers and parents. But okay, good. So good deal. No superintendents, right? We're free to talk. All right. So good. All right. So I call this the toolbox. It's something that I created. Why did I create it? Because this is the most complicated area of special ed law that exists. You know, if you ever take the time to really read the procedural safeguards document that you give to parents all the time, about a third of it is dealing with discipline. And so this is a complicated area. I've been doing special ed law for 40 years. And this is the most complicated part I've bumped into. So if you find it confusing, if you run into a situation and you wonder, what do we do? Don't get down on yourself. This is confusing stuff. And that's why I sat down one day and I thought, let me see if we can put it into a framework that's a little bit easier to understand. So that's what the toolbox is all about. So here's the deal. Federal law requires you guys to do two things at the same time, and it's very difficult to do both of them at the same time. Federal law expects you to serve all students with disabilities and to do it in the least restrictive environment. You know, it used to be that kids that were seriously disruptive at the school were expelled from school. That is not an option anymore with students with disabilities. So we have an ongoing obligation to find a way to serve them. And it's always supposed to be in the least restrictive environment. So that's one thing you have to do. The second thing you have to do is maintain safety. And I'll bet you if you surveyed your parents, they'd rank that as your number one responsibility, maintain safety. So you got to serve students who sometimes will not be safe to be around, and you have to serve them in the least restrictive environment, and you have to maintain safety. So how are you going to do that? So that's what the toolbox is all about. So it's a set of tools that are designed to help you do both of those at the same time. Okay? So that's what we're doing. So I'm going to show you the tools. Now I only put, here's 8 of them, and you may wonder, well, why did he put 8 on one slide and 2 on the other? Because of the font, okay? There's no other mystery to this. So just, you know, I hate it when the PowerPoint, and this is a small group, but I present this to large groups, and, you know, people in the back can't read a small font. So that's the only thing. However, it's true that these are a little bit different, but if you have copies, I don't know if you guys have copies of these, but if you did, if you don't, just think about this. You should draw a line between 1 and 2. You should draw a line to separate tool number 1 from all the rest, because tool number 1 is different from all the rest. Tool number 1 is number 1 for a reason. It's the most important tool. Tool number 1 is the only tool that we have where the purpose is to improve the student's behavior. So if tool number 1 works, we can put away the toolbox. We're not going to have to use any of the other tools. Okay? Now it rarely works that well, so we need all 10 tools. But tool number 1 is there for a reason, and so we'll talk about behavior plans a little bit. Now I want you to notice that there's 3 of these tools that are a change of placement. So 3 of the tools involve, what do you call it, case conference committees, having a meeting, proposing a change of placement, to which the parent either agrees or doesn't, but that's what we're there to talk about. So there's 3 of them that are a change of placement. And you know that if it's a change of placement, this is something that is going to change where the student is served for more than 10 days in a row. That's a change of placement. So 2 of these are referenced as educational changes of placement. What does that mean? That means it's not a punitive consequence, it's not punishment, it's not discipline. We're doing it for educational reasons. And so typically educational changes of placement are based upon, I mean, they can be based purely on academics, but if it's based on behavior, it's going to be based on behavior that is a manifestation of disability. So let's say we have a student who has a serious emotional disturbance, or a student who is on the autism spectrum, and the student is engaging in a lot of behaviors that are disruptive or inappropriate, and they're all a manifestation of disability. We don't want to punish the student for that. We don't want to take disciplinary action. That would be discriminating on the basis of disability. But the student's not in the correct placement. We want to move the student to a more restrictive environment. So that's what we mean by an educational change of placement. It's moving the student typically to a more restrictive environment because of behavior that is a manifestation of disability, but is disruptive or maybe even violent. So those are educational changes of placement. And you notice there's 2 ways to do it. There's the easy way, that's tool 2. There's the hard way, that's tool 3. The difference being whether the parents are on board with this or not. Number 4, we'll get to that in a second. I like to talk about, this is an all-day presentation I do. You guys are getting an introduction in an hour and a half, but this is an all-day presentation. And when I have all day, I always try to make sure that people understand whose tool we play, whose tool is it? Who has the authority to operate that tool? So let me just ask you, who has final approval authority for a behavior plan in Indiana? It's in your rules. I looked it up. It's a case conference committee. I'm sure you probably have someone who drafts a behavior plan, but that's not the end of the deal. It has to be presented to the case conference committee. Therefore, the parent is a part of this, and the case conference committee approves it. So whose tool is number 1? That's the case conference committee's tool. Who changes placements? Case conference committee. So tools 2 and 3 are tools that can only be operated by a case conference committee. So 1, 2, and 3 all belong to the case conference committee. I'm getting pretty comfortable with that, you know, that case conference committee. You guys are the only state that has that. Do you know that? Good for you, Hoosiers. Unique, all right? I think New York calls it the Committee on Special Education. Most states call it the IEP team. Federal law calls it the IEP team. Of course, we in Texas, of course, are unique. We call it the ARD. That is the Admission, Review, and Dismissal Committee. Some people think it's anguish, remorse, and denial. I say, no, that is not true, not true. It's admission, review, and dismissal. So we have ARDs, and which is handy because if we've had a really difficult, contentious one, we know where we've been. It was a hard ARD, all right? so anyway, so I'm getting pretty comfortable with CCC now that I've been here for 3 days. Tool number 4, I would call that the superintendent's tool. I just heard the tail end of David's presentation, and that's what he was talking about at the end. Seeking an expedited hearing right now because we really have a crisis, and that would be something where it kind of looks like the school is suing the parent. I don't think your superintendent is going to want to have anybody else authorize that but the superintendent. So, and we'll talk about that in a little bit. Now, tool number 5, principals and APs, there's your tool. Because with tool number 5, you do have the authority by yourself to order the removal of a student for a good long time. It could be as long as 45 school days that you order the student removed from the placement that the case conference committee put the student in. But it's only when you have one of 3 special circumstances cases. So that's tool 5. Now, tool 6 is the only tool that cannot be used when the behavior is a manifestation of disability. If you have a student who's engaging in behaviors that are caused by the disability, You have 9 tools that are available with that student, but not number 6. Number 6 is a disciplinary change of placement. In other words, it's imposing on the student with a disability the same consequence that the general ed student would have for engaging in that behavior. Okay? I don't know if you all have detention schools, or I don't know what that looks like in Indiana, but that's a disciplinary change of placement. So we can only do that if the behavior is not a manifestation of disability, because this is punitive, this is discipline. So we only do that if the behavior is not a manifestation. And who decides that? Case conference committee, again. So that one's going to run through the case conference committee also. Number 7 is the 10 days that the principals have unilateral authority to remove students. I call it the fate-free zone. I'll tell you why in a little while. Well, I told you that in the big group, didn't I? Didn't we already go through that? Okay. I hate it when I've already used half of my shticks and I still have the same audience, you know? We'll try to come up with something new here. And then we have tool number 8. Now, when I get to tool number 8, I'm going to ask you guys to perk up because it's the most complicated one. So I don't want you tired when we get there. But this is the answer to the question, what do I do when the 10 days have already been used up and the student continues to misbehave? Because believe it or not, there are kids that do that. There are kids that, you've removed them for 10 days and they're still doing something that's problematic. What do we do? Well, that's tool number 8. So now the last 2 that didn't fit on the slide, leadership at the IEP team meeting, or CCC meeting as it were, and calling in the cops. So those are the 10. I created the toolbox, and I probably could have reduced it to 7 tools or expanded it to 13 because it's kind of a manner of how you slice these things. But 10, everybody likes 10. Moses came down the mountain with 10, you'll recall. The Bill of Rights have 10. The Big 12. How many teams are in the Big 12? 10. That's till Texas and Oklahoma depart, but right now, 10 teams. How many teams are in the Big 10?
16.
14. No. Yeah, 14. Who are you counting that I'm not thinking of?
I don't know, but I'm hurt that I'm a Big 10 fan, so.
Oh, I'm pretty sure it's 14.
No, I'm not saying I don't believe you. I'm saying that I was incorrect in front of all these people, and I'm a Big 10 diehard.
Oh. Feel a little shame, do you? A little embarrassment? It's okay. All right. Can we give her a round of applause to let her know? But the thing is, the Big 10 insists on calling itself the Big 10 when we agree that whatever number it's got more than 10. But everybody likes 10. So we went with 10. So there's no magic to it. That just was what I decided to do. Okay, so that's the background on this. So let's talk about behavior plans. Now, like I said, this is the first tool for a reason. It's the most important tool. And it's the tool that, if it works, we can set aside everything else because we have an improvement in the student's behavior. So that's the most important one. It is proactive, it is positive, it is aimed at specific behaviors. The law really doesn't define BIP. Now, Indiana has some regulations that kind of lay it out. It does say that it has to be approved by the case conference committee. But Indiana's regulations pretty well mirror what's in the federal regulations, and I wouldn't call it a definition, I'd call it a description. And the description they give is positive behavior intervention strategies and supports. So, my shorthand expression here, and I think I shared this with the big group, it's not what you do to the student, it's what you do for the student, okay? So what we do for the student, how we do, your code of conduct is going to tell what we're going to do to the student. And I don't know if you've ever noticed it, but nobody reads the code of conduct until some student does something so creative that we're not sure how to classify it. We know it must be wrong, but we don't know how to classify it. So I'll tell you an example of this. This happened in a school district outside of Austin a year or so ago, and the only reason I know about it is it was in a little blurb in the newspaper, and I thought, oh my God, that's a good story. So I'm going to tell you the story. So apparently this kid called a stripper and arranged for her to show up at the middle school to entertain the assistant principal. So, the stripper turns out to be the hero of the story. I read this blurb, and I thought, this girl must have been in the National Honor Society. I mean, she handled this just right, because here's what happened. She apparently is on the early morning shift. She gets the text message from her dispatcher, report at 9:30, ask for Mr. Johnson, and it gives an address. Okay, so she gets ready, she goes over there, she pulls up in front of the school, and she sees, oh my God, it's a middle school. This is a prank. You know, this is not for real. So she could have turned around and gone home, and we never would have known anything about it, you know, but she went into the school, she introduces herself to Mr. Johnson, she said, I am Destiny or whatever, from whatever, and I'm here to entertain you. You probably don't want that right now, but here's the important thing she did. She said, here's the credit card that got me here. And so the credit card, they traced it back to the student, and they call the student in and they have a little chat. Is that in your code of conduct? I don't think so. Do you want to put it in your code of conduct? Calling a stripper to the school? You don't want to list that. And don't you have a list of things you can't do? You don't want to put in there, yeah, bringing a stripper to the school, because what will happen if you put that in there? Hey, look at that. There's a good idea. But see, nobody reads the code of conduct until something like that happens, and then you have to figure out, well, I know it's wrong, but why? What do we do? How do we classify this? So it is a reactive document. It's reactive. That's my point in telling you that story. A BIP is proactive. That means it's like an IEP. When you write an IEP for math, you don't wait for the student to fail in math. You've already said what we're going to do to help teach the student math, and you do it every day. Same thing with the BIP. You don't wait for the student to misbehave because you've written a BIP. You proactively provide services that will prevent it. It's about prevention, okay? So, where did I put my clicker? Here we are. So some basics about these. You know, here's the thing that triggers thinking about a BIP, and this is in your forms. I know it's in your forms. I know it's in your forms because it's in the law. The law says that every year the case conference committee must ask itself, does the student have behaviors that impede the learning of the student or others? And if they do, we have to address them. And it doesn't have to be done with a behavior plan, but it certainly can. So I want you to notice something about it. We identified the behavior that impedes learning. We set a goal. And that's the way I read the Indiana requirements. It says that a BIP is a part of the IEP. All right? Well, I think that has some implications. If it's part of the IEP, shouldn't it be just like any other part of the IEP? Present levels of performance, measurable goal, some way of determining whether we're making progress or not, and a description of the services that we're going to provide. Proactive interventions, strategies to encourage and nurture better behavior. Okay? So I want you to notice that when we ask that question, does the student have behaviors that impede learning? We're not asking if the behaviors are disability related at this point. That's not the issue. The issue is simpler than that. The issue is, does the behavior impede learning? And if it impedes learning, it needs to be addressed. You may have a lot of students with disabilities who have behaviors that have nothing to do with the disability, but they're impeding learning. That needs to be addressed. We should be thinking about a behavior plan for those kind of behaviors. And you know, for that reason, I think you need to be thinking about a BIP more often than this once a year. You definitely have to think about it once a year. It's in the law. I would also encourage you to think about it every time the student has engaged in some serious type of misconduct. Take, for example, I get a lot of pushback on this sometimes in Texas because I tell people, if you have a student who's committed one of the more serious types of offenses at school, such as possession or sale of drugs at school, I don't know of a school that doesn't treat that as a pretty serious violation of the code of conduct. It's also a behavior that impedes learning. That's why we prohibit, that's one of the reasons we prohibit it. That's one of the reasons why it's illegal. It impedes learning. So should you be thinking about a behavior plan for that student who is selling drugs at school, selling his mother's prescription medication? I think it's a behavior that impedes learning. What are you going to do to proactively address that? I don't know the answer to that question, by the way, but I think you need to be thinking about that. So you might want to put this into some of your forms, in your IEP form maybe. Identifying a behavior that impedes learning does not mean that the IEP team has determined that the behavior is a manifestation of disability. It only means that the behavior impedes learning and should be addressed. I think that's a simple, straightforward statement that people will understand, but I think that might be good. See, I'm aiming a lot of this at principals because I've had principals that are fearful of writing a BIP because they think that ties their hands if they want to take disciplinary action later. And I don't think it does. It certainly doesn't have to, not if you write it that way. That when we say the behavior impedes learning, that's all we're saying. And if it's not a manifestation of disability, we might take negative disciplinary consequences. So those are two separate issues. Behavior that impedes learning is one thing. Behavior that's a manifestation of disability, that's another. I think I mentioned this in the big group, but just a quick word about, the things that, and this is just my opinion, so take it for what it's worth. But I think there's three things that have no business being in a BIP. Calling the cops, using physical restraint, and short-term negative consequences. Now, why do they not belong in a BIP? Number one, none of those are positive behavior intervention strategies or supports. They're all negative things that you do to the student. Number two, you don't have to authorize them. Some people think, well, we have to authorize. It has to be in the BIP because we have to make sure the parent understands that this is something that might happen. The parent does need to understand that it might happen. It's in the code of conduct. It's in the state law. It's already authorized. You don't need to do anything beyond that. I started thinking about this, so I got a call. A lot of what I came to believe comes from a phone call, because I've taken thousands of phone calls over the years from special ed people. Got a call from somebody. They said, we're having a big fight with the parent over whether or not we should ever call the police. I said, well, you have the authority to call the police. Yeah, we know. Well, we're trying to put it in the BIP, and the parent's really strongly objecting to that. I said, well, you don't really need to put it in the BIP. It's authorized by law. It's authorized by your code of conduct. It's authorized by your school policy. Why are you putting it in a BIP? Well, we want to make sure the parent make sure the parent knows that, that's in the code of conduct. We might do that. Don't have an argument with the parent that you don't need to have, Let's not fight over whether we put it into the behavior plan. So those are things I would suggest don't belong there. Okay? All right. Question. Does somebody have a question? Yes, ma'am. Good for you. A bus attendant is doing what? They're actually driving them, or they're attending the bus? They're
The attendants.
Okay, the attendant.
So if they in fact do have to restrain the child,
Mhm.
you still wouldn't want that in the
I wouldn't put that in a BIP, no.
Okay.
Because her question is about, when you say bus attendant, you mean not the driver, but the other person that's there to kind of make sure the kids are safe and all that, right? That's what we're talking about. And if it's necessary for the bus attendant to restrain a student, I don't think that needs to be in a behavior plan. Again, it's not a positive behavior intervention. You wouldn't consider that a happy call if the school called you and said, we had to restrain your child this morning. That's not a positive behavior intervention. And your state law does require that people that use restraint have to be properly trained.
Correct.
I would hope that the attendant, if we can predict that she may have to use physical restraint, I would hope that person is trained. So, there's legal requirements for restraint, don't get me wrong, but it doesn't belong in a BIP. It's not a positive behavior intervention, and it's already something that's authorized. And if you think about when we use physical restraint, if we do physical restraint properly, we're only using it when the failure to do it would lead to bigger problems. We restrain a child because if we didn't, that child is going to get hurt or that child's going to hurt somebody else. That's when we use restraint. So it's an emergency. That's why you can't predict it. And you can't promise a parent will never use it. We can't promise that because we don't know what's going to happen at school tomorrow. We have some kids for whom it's predictable that we may need to use physical restraint. We need to be sure that the people that are around that student are trained. Yeah, those are other legal requirements that apply to the school, but I wouldn't put it in a behavior plan. Okay. Yes, certainly you have to have that in Indiana. Indiana says that the behavior plan is a part of the IEP. It's approved by the case conference committee, so changes in it are just like changes to an IEP. They have to come to the case conference committee. That means the parent has a seat at the table. Okay? Okay, good questions. Thanks. So let's go on to changes of placement. So 2 and 3 are both educational changes of placement. So this is when the behavior is a manifestation of disability. But the school is of the opinion that the current placement is not suitable for the student, it's not working. And I'll tell you, when this comes up a lot, when I do, most of the presentations I do are for administrators and special ed staff. But sometimes there's some teachers, and sometimes I get a chance to talk to classroom teachers, which I always find very interesting. So when I talk to teachers about this stuff, I can predict one of the questions that's going to come up. And here's how the question's going to come up. The teacher's going to raise her hand. She said, I have a question. Okay, what is it? She said, well, I teach 4th grade, and I have 22 students in my classroom. She said, I don't really think of them as 22 students anymore. The way I think about my class is I've got 21 students, and then I got Jacob. All right? Now, you know the rest of the story, don't you? You know where the teacher is headed with this. And I do too. I know what the question is. She said, you're talking about Jacob's rights, and I understand that, and I'm all for Jacob having his rights, and I'm for Jacob's parents having his rights. What about the other kids? That's the question. She said, Jacob is the one I'm worrying about when I'm driving to school. Jacob is the one that's got me thinking maybe it's not too late to go to law school. Jacob is the one. I'm getting phone calls and emails from the parents because they're hearing stories of what Jacob did in class. What about the other kids? That's when tool 2 and 3 are things that you may want to think about. So if you have a situation where a student, and typically this is a student who is in the mainstream, and the school comes to the belief that, this isn't going to work too well. We need to move this student into a more structured setting. So you need to lay the groundwork for that. That is not something you spring on a parent at a case conference committee. That is something that you let the parent know well in advance. Not that we're going to change placement, but that we're having some difficulties, that it's not working as well as we would like. And we solicit and value parental input about that. That term, solicit and value parental input, schools always say that, and I'm not cynical about it. I think they mean it, but in special ed, they by God better mean it. Because in special ed, there's legal consequences when you don't solicit and value parental input. So if we have Jacob, and the 4th grade teacher is telling us, Jacob doesn't belong in my classroom. I'm doing the best I can, but I'm telling you he doesn't belong. We don't want to spring that on the parent. We want to enlist the parent, enroll the parent in working with us to see, do you have some ideas about how we can make this better? And so we talk about that. Now where did I put my, oh, there it is. So we may think about a change of placement. So that could be tool number 2. These are both changes of placement. There are more than 10 consecutive days. And tool number 2 is done the easy way, and that is that the parent sees the wisdom of it. Or maybe the parent has requested it. Sometimes it's the parent who wants the student to move to a more restrictive environment. And the school says, okay, we're good with that. Tool number 2, moving the student to a more restrictive environment. But I'm here to talk more about tool number 3 because that's where the law comes into it. Tool number 2 is easy. You have a case conference committee. Everybody sings Kumbaya at the end of it. And we've got ourselves a change of placement. Tomorrow the student's in a different location. Okay? Tool number 3, not so much. So it's an educational change of placement, but you didn't get the parents' agreement. And you need to be able to prove 3 things. Number 1, this is not working. I don't have 22 students. I got 21, and then there's Jacob. It's not working. It's a dysfunctional situation. Number 2, we've really tried hard to make it work. I asked a principal one time, have you tried inclusion? He said, yes, last Thursday. It didn't work. I told that story already, didn't I? All right. But you have to show that you really work. By the way, if you haven't tried tool 1, then you can't satisfy factor number 2 here. We want to move the student to a more restrictive environment. Does the student have a behavior plan? No. Well, then it's premature. It's that simple. It's that simple. Let's try a behavior plan. I'll get to you in just a second. And then let's talk about it. So also, what else do we want to do? We want to solicit and enroll and listen to the parents' input. We want to collaborate locally. Maybe some other teachers are having more success with this student than this teacher is. Maybe last year's teachers had a good experience with the student. Maybe we want to reach out to our regional service center. Do you guys have that here in Indiana? Some sort of regional? You got the IEP Resource Center. Anyway, reach out to some people, do some things, show that you're really making the effort to make it work. And then the third thing you have to be able to prove is, you know, I got 22 students, but I think of them as 21, and then there's Jacob. We're not doing this just for the benefit of the 21. This is good for Jacob. Here's why. If we move the student to the more restrictive setting that we have in mind, here are some things we'll be able to do that it's not feasible to do in the current arrangement. It will be better for Jacob. And we want to have a plan to move Jacob back to the less restrictive environment. That, you know, nobody is consigned forever to a more restrictive placement. We want to have a plan for moving him back. So those are the things you need to be prepared to prove. And I'll get to the 3 questions in a second, but you had your hand up.
No.
Oh, you think it's simple. I'll make it complicated. If you didn't hear the question, it's about a student who perhaps is new to the district, and we don't really have much personal experience with the student. We do have information from the other district. And the committee should be making its best decision based on you know, all they can do is act on the information that they have currently. But if the student is brand new to the district, you know, the starting place is how was the student served in the other district? And the new district should be trying to match that as much as feasible. That would be the starting point, at least in thinking about it. Well, gee, these guys had this student in the mainstream for everything except English language arts. They had the student in resource for that. That would be my starting point. Or my starting point would be, well, that's where we're going to start, okay? Because all we know about the student at this point is what they did in the other district, okay? So, tool number 3, you really need to ask these 3 questions. Is this worth fighting over? You know, you guys ask that question all the time. School administrators ask that question every day. Mask mandates, is that worth fighting over? Quarantining people after close contact, is that worth fighting over? A whole lot of issues coming up about all this in connection with COVID. Is this worth fighting over? So, you know, I think there's a lot of fights that we can have with parents that are not worth fighting over. They really should try to see if we can find some resolution of it. But when I go back to, I got 21 kids and then there's Jacob, if that's really the case, I call that something worth fighting over. So is it worth fighting over? Number 2, are we legally defensible? Now ask that question of the right person. Don't ask that of the special ed director, with all due respect. Don't ask that of your nephew who's in his 2nd year at law school. Ask that for a school attorney who does know something about school law, about special ed law. You know, there are school attorneys, and then there are school attorneys who do special ed. And if you're in this situation, I would encourage you to get with an Indiana school attorney who knows something about special education law. And so, are we legally defensible? Unfortunately, you may contact the best lawyer in Indiana. That lawyer's not going to be able to give you an answer in 15 minutes over the phone. To answer the question, the lawyer's going to have to spend a good bit of time, because we're going to want to look at least 2 years worth of records probably and interview people who have been interacting with the student. You really don't know if the school district is legally defensible until you put in the time to do that. So it's, you know, there's going to be some investment in attorney's fees right there, right off the bat. And then, are we united? You know, these first 2 questions are not unique. I mean, these first 2 questions are not unique to special ed. Like the examples I was just giving you, mask mandates, quarantining, how we're going to respond to all this stuff these days. Your superintendent and school board are making those decisions, and it doesn't really matter whether the rest of the staff agrees with it or not. In fact, I'm sure there's people on the staff who disagree with whatever the superintendent does. That's just the nature of it. But this question is unique to special ed, because if we do end up in litigation, you know who's going to be the most important witnesses? Not the director of special education, the teacher who has spent the most time with the student in the classroom. Sometimes the paraprofessional who maybe doesn't have a certificate, but is in the classroom with the student every day and can give us direct testimony about how things are going. So if those people do not support what the administration has proposed, then we're not united, and we better not go forward, okay? So I start with question number 3. You know, I want to know if the staff is united about this. Does everybody think, yeah, you know, it really is time to move Jacob? We've tried hard, it's just not working. We need to make this move. If the staff is united, then maybe we're legally defensible, because if the staff is not united, we're not legally defensible. If we're not legally defensible, I don't want to have a fight. It's not worth fighting over. So I kind of take them in reverse order there, okay? So yes, ma'am.
So hypothetically speaking.
Oh, they're never hypothetical, but go ahead.
If we were talking about the reverse of that, if we had a student in a more restrictive environment and we're told that the student has made progress and is ready to move back to mainstream, what should be in place? What should be shown from data in order for that move?
Okay, you have a student that currently is being served in a more restrictive environment, but teachers, I guess, are reporting, we think the student can be successful in the mainstream classroom. What do we need to do? Need to think about it. We ultimately need to have a case conference committee to consider, now you're talking about a change of placement to a less restrictive environment. We want to talk to the parent about this, make sure the parent is on board. We want to look at the current IEP and see if it can be implemented in the mainstream, or do we need to change it? So all of that's what you'd want to do. But the main thing, I would do, one thing about these changes of placement that don't have parental agreement, you always have to think about how the stay put rule is going to come into play. I told you about that case from Comal in the big group where the school district tried to get a change of placement. It went from August to March with the student in a stay put situation. And then the school district gets validated by the hearing officer. They win. The hearing officer says, you're right, school, the student should move. And the parents say, well, we're going to appeal it, so stay put's still in effect. So, I always think you need to, that's one reason why it's so important to solicit and value parental input and work to see if you can get parental agreement, because it'll go a whole lot easier if you do, obviously. Okay? Hope that answers your question. Okay, one more thing about Tool 3. That's what I just said, the stay put rule. So that means the student may not be going anywhere. So like in your case, in that case, that hypothetical case, you were hypothetically asking me hypothetically, if the school says, Mom and Dad, we think the student is ready to go to mainstream, and the parent might say, no, I don't want that. Well, if the school pushes it, they can, but the student's going to stay put in the more restrictive environment until we get through that process, okay? So, all right, tool number 4. Now this one's very rare. I've been doing this toolbox for about 6 or 7 years now, and it just dawned on me, I probably should put tool 5 before tool 4. So I think I'll do that. Let's just do that right now. So we'll do tool 5 and then we'll come back to tool 4. If I go on to tool 6, somebody call me on it. Blow the whistle. Say, hey, back to 4. So this is the special circumstances removal. And this is the authority that has been given to principals because these offenses are considered particularly serious. So I can tell you a story about this to let you know how the law changed. This wasn't originally in the law. Principals didn't have this kind of authority. Any change of placement for more than 10 days had to be approved by the case conference committee. I think Congress started hearing stories about that, about how that hamstrung campus administrators in some cases. So let me tell you about this case that my law firm was involved in. It was a small district out in West Texas, and they had a really zero tolerance kind of policy with regard to drug possession. Single joint of marijuana, you're out for the year. They had 2 7th grade boys passing a joint back and forth on school grounds during the school day. I mean, it just couldn't be more clear. There they were, they got busted just red-handed. So what's the principal want to do? Above all, the principal wants to treat them the same, right? The principal doesn't want to be accused of any kind of favoritism or bias or prejudice. The principal wants to treat them the same. So one of them, of course, was special ed. And so there's where the problem arises. He couldn't treat them the same. The general ed student was given due process. It was determined that he did commit this offense. The penalty under the code of conduct was expulsion for the year. He was expelled. All right? Special ed student was given due process. It was determined that he committed the offense. They took it to the Texas version of the case conference committee. They said this had nothing to do with his disability. He was expelled, but the parent requested a due process hearing. What happens? Stay put. He's right back in school. So you got 2 boys who did the same thing. One of them is still in school, one of them is not. And people in the community kind of noticed this, but they didn't have all the information that they needed. What they noticed is that Johnny was in school and Jose was not. Now, what does that sound like? Good old West Texas racism. And the school couldn't say anything about that. Well, Johnny's got a learning disability, bless his heart. That's why he's in school. We couldn't say that. That violates confidentiality laws. I think Congress heard enough stories like that that they created special circumstances. So they said that the principal can order the removal of the student for a period of time. Obviously, it has to be consistent with your code of conduct. But it can be for as long as 45 school days. That's 9 weeks of school. That's a long time. And this does not require case conference approval. So this is principal's discretion, can be done. And it has to be to what they call in federal law an IAES, an Interim Alternative Educational Setting. My impression is you guys don't have a whole lot of that in Indiana. Texas is kind of fortunate, I'll tell you, because our state legislature a couple decades ago forced this on us. They required every school district to set up what is called a DAEP, a Disciplinary Alternative Education Program. And it was designed to continue to serve kids that otherwise would have been expelled. And it's not just special ed kids, it's general ed students that are there. So we have that. But the principal can remove the student to one of these IAESs. It still has to go to the case conference committee. And the case conference committee still has to do a manifestation determination. But regardless of the outcome, the student can be removed. So people may wonder, well, then why are we even doing a manifestation? I think the manifestation influences the behavior plan. But it doesn't alter the placement of the student, okay? So it's only these three offenses: drugs, weapons, and the infliction of serious bodily injury, okay? So let's talk about those a little bit. The part about drugs does not say drugs or alcohol. There's a lot of statutes that lump those two things together, drugs or alcohol. This one doesn't. It says drugs. And I don't think that means vaping, by the way. But it means whatever, and I think marijuana is still illegal here. Is that right? Yeah. You're behind the times like we are in Texas? Okay, we'll all get there eventually. But that's illegal. A controlled substance. That could be a prescription that's not mine. You know, if I'm in possession of my dad's prescription painkillers that have not been prescribed for me, that is a controlled substance. That's a drug. So drugs. It also doesn't include being under the influence of drugs. So you have a student perhaps who's having a marijuana brownie for breakfast every morning and waking up very happy. But the student doesn't have possession of it at school, isn't using it at school. That's not a special circumstance, okay? Weapon can be anything readily capable of causing serious bodily injury. So a baseball bat is not manufactured to be a weapon, but if I bring it into the classroom and start swinging it at people, it's a weapon. So the possession of a weapon is one of the special circumstances. That could be something as small as a knife with a blade of 3 inches. Now, you know, here's where you have to use some common sense. Let's say you have a student who is in possession of a small pocket knife with a blade that is literally 3 inches long. And the student doesn't threaten anybody with it, doesn't even take it out of her purse, but there it is. I don't know, do girls even carry purses to school anymore, or is it all backpacks? Let's go on to backpacks. It's in the backpack. Somehow we find it, you know. You could remove the student for 45 school days, but I don't think that's what you would do with a general ed student who did the same thing. I think you'd probably do something a lot less harsh than that, if anything. You might not do anything. Anyway, so, and then we have serious bodily injury. Now let's talk about that a little bit. Has anybody here had a broken nose? I always like to find out about this. You did? Wow, okay. Well, they put it right back on in the middle of your face there. They did a good job. Looks, you have a nice nose.
Thank you.
Yeah. I'm sensitive to noses. I don't know if you can tell. I've never had a broken nose, but I had forehead flap surgery last year. Has anybody ever heard of that? Do you know about that? So there's a skin cancer on my nose. So they took it out, and that was easy enough. But then the doctor said, you know, we're going to have to cut some skin from your forehead and pull it down under your nose because we kind of excavated your nose. I'm giving you too much information now, aren't I? My children keep telling us, Dad, quit showing people those pictures. It's not, don't show them the pictures. So I had 3 surgeries, forehead flap surgery. So this doctor who did the surgeries, he kind of eyeballs me, and and I see the look of envy in his eyes, because he's in his 40s and he doesn't have the great head of hair that I got. I see this from younger men periodically. I'm 71 years old. This is a pure gift from God, but I'm grateful for it. But he says, we might have to carve all the way up into your scalp, and if we do that and we put that on the side of your nose, yes. I shave my nose every morning. Too much information, right? Oh my God, and we're recording. So I think I need to go to the makeup counter and say, 'cause I don't know. You can tell right here. See, it's right here. So I scrape it off every. Yeah, it's a melanoma. It was a melanoma. They got it all, so it's no big deal. But how do we get into this? Oh, you had a broken nose. Okay, how bad did it hurt? Pretty bad. Well, let's go 1 to 10 scale.
6.
6. Okay, her broken nose was a 6. Now, as your lawyer, let me ask you to reconsider that question just a little bit. I want you to reflect for a moment on the moment of impact, the shock, and the fact that you probably knew immediately the doctor's going to have to reset this, and that's going to hurt even worse. As you reflect upon the pain and anguish you must have felt at that moment, would you reconsider where you'd put that on a 1 to 10 scale?
Probably not.
Huh?
Probably not.
Not. I'm not a very good lawyer. This is what you call leading the witness. And I totally failed. What was she supposed to say? 10. Did you miss the clue? Is it you or is it me? One of it. Okay, why am I making fun of this? Because if you don't say it's a 10, I don't think you have a serious bodily illness. Seriously, there have been cases where they've used the 1 to 10 scale. And I saw this one from California that really kind of shocked me. The hearing officer classified it as a serious bodily illness. Well, what happened? It was a teacher, a woman, and she was dealing with a 6-year-old. Not a 16-year-old, a 6-year-old. This 6-year-old kicked her and headbutted her in the chest. I'm sure it hurt, all right? I'm sure it hurt. She said it was the worst pain of her life. Really? I said, she has not experienced childbirth. Of this, I'm pretty sure, But she said it was a 10 on the 10-point scale, So, here's my rule of thumb. If you didn't call 911, then I don't think you have it, You might have, now by the way, the serious bodily injury might be inflicted on a fellow student, or it might be on a staff member. It could be a teacher. It could be you, anybody at the school, if the student inflicts serious bodily injury. And my rule of thumb is if you didn't call 911 for emergency medical help, you probably don't have it. Maybe the teacher misses 2 days of work. Maybe the teacher has pain for a week or so. If you didn't call 911, you probably don't have it. If Congress took the word serious off of this, if it just said bodily injury, principals would be using this every day. And that's why they will never take the word serious off of this. This was giving principals a little slack, but they wanted to put some guardrails on it. Only drugs, only weapons, only serious bodily injury. Saw a couple of hands go up. Did you didn't?
My question was about the weapons.
The weapon.
We had a student steal an X-Acto knife from art class.
He stole what?
An X-Acto knife.
Oh, an X-Acto knife.
Well, he kind of borrowed it, I think, but he didn't have one at home, and he really wanted to use it for a project.
Right.
And he put it in his backpack and left it there, and then we realized it was gone and found it. And the school wanted to suspend pending expulsion for possession of a weapon.
Not for theft, but for possession of a weapon?
And I said it couldn't be considered a weapon if 5 minutes prior it had been considered a tool.
Well, it could have if he threatened somebody with it.
Right.
If he pulled it out and he threatened somebody with it, then it's a weapon. The same thing with the baseball bat. The baseball bat's a baseball bat. But if I'm swinging it at people's bodies, it's a weapon. Same thing with an X-Acto knife. But I agree with you. If he just put it in his backpack to take home, he's not threatening anybody with it. He's not using it against anybody. It's not a weapon. And an X-Acto knife doesn't have a blade of it's not more than 2.5 inches, right? My recollection of X-Acto knife is a little tiny blade. So it's not going to meet the definition of an illegal knife, and it doesn't meet the definition of a weapon because it's not, it says used for or readily capable of causing serious bodily injury. Well, yeah, I know, yeah, an X-Acto knife is readily capable of that, but only if you are actively trying to use it in that way. So yeah, I would agree with you. I think they'd have been better off to charge a student with theft because he stole it from the art class, right? That's a violation of your code of conduct. Yes, ma'am.
So does this include threat of serious bodily
No, it
injury?
does not include threat of serious bodily injury. That's a good question, and you know, that's a violation of the code of conduct. The threat of injury is by itself a violation of the code of conduct. Can the school deal with that? Well, of course they can, but I wouldn't use Tool 5. Tool 5 also is not psychological injury. You can be psychologically traumatized by an incident at school without having any physical injury. But the law says serious bodily injury, and all three words are important. Yeah.
It can't be self-inflicted.
Huh? Self-inflicted?
So if the student inflicts serious bodily harm to themselves.
No, I don't think so. No, I'd have to go back and look at it, but I'm pretty sure it's talking about inflict somebody else. Okay. So that's another problem. We want to address that.
Yeah,
but I wouldn't pull out Tool 5. Say you hurt yourself. No, I don't think so. Let's deal with that in some other way. Okay. It's good questions. Good for you guys. I like it when you have some questions, especially afternoons because we get tired and hot. Difficult. All right. All right. So now is somebody going to remind me we have to go back to Tool 4? You were right on it, right? Okay. All right. Let's go back to 4. I can't change it because I've been doing it this way for a long time, and it's in the book. I've got a book, So here's the expedited hearing. So the school district can request an expedited hearing here's why this is the least used of the 10 tools. Because the circumstances that would authorize the school to use this tool, it's a rare confluence of circumstances. Number one, you have to have student behavior that is a manifestation of disability. Now, why do we say that? Because if it's not a manifestation of disability, you use tool number 6. That's a disciplinary change of placement. Number 2, the parent will not agree to a change of placement. Why do we say that? Because if the parent will agree to a change of placement, that's tool 2, and that's pretty easily done. Number 3, see, I left this out. I need to change the PowerPoint. You don't have special circumstances. That's why I need to do tool 5 before this. But I should have added that to the PowerPoint. I'm sorry about that. That's just an oversight. But the third factor here is you don't have special circumstances. Why is that important? Because if you did have special circumstances, you'd use tool 5. It's pretty easy, tool 5. So you have all these things come together, and you think this kid is likely to hurt somebody if you leave them where they are. See, if the school proposes a change of placement and the parent doesn't agree to it, then the rule is the student is supposed to stay where they are, unless you have special circumstances. And so the student's going to stay where they is. Well, the school says, well, this kid's going to hurt somebody. Now, you can go to court. You can get your lawyer to go to court. You can file a request with the Indiana Department of Education and ask for a due process hearing, and they will appoint a hearing officer, and they will hear your case. But you have a pretty heavy burden of proof. You have to prove that if this student stays where he or she is, somebody is very likely to get hurt. Now, how are you going to prove that if nobody's gotten hurt so far? I don't think you do. If I were the lawyer and I go into court and I say, Your Honor, if this student, we want to move this student out, and we can't do it, we can't use a discipline thing because it's a manifestation of disability. The parent won't agree. There's no special circumstances, but Your Honor, if this student stays where he is, somebody's going to get hurt. Well, counsel, how do you know that? I know the judge is going to ask me that. Why do you think that? Well, how about if I say, well, I just do. That's what I think, That's what I think. And that's what the school people tell. A lot of people say that. That's what the school people tell me. How's that going to fly? I think the judges say, you have not carried your burden of proof. You have to prove that this is substantially likely. And I don't think you can prove that the student is dangerous if the student hasn't already hurt somebody. If they already hurt somebody, then I'd take a good hard look at tool 5. Was there a weapon? Was there a serious bodily injury? You had a question?
I was just going to say, we did have a situation like that.
Like this?
Yeah, we filed an injunction because he had texted pictures of weapons and knives
Okay.
and verbal threats as well as
And the social media
all of
posting,
that
yeah.
came up
Yeah, that would,
along with, because he hadn't hurt somebody, but the imminent threat and his behavior escalated, so we brought that body of evidence and we actually.
and you got the,
prevailed.
yeah, this is sometimes called a Honig injunction. Lawyers will call this a Honig injunction after the court case where this comes from. And that's a good example of how it might happen. It's the student hasn't recently hurt somebody, but look at all the social media posts. Look at the threats we're picking up. And you know, in the era when we're terribly frightened of school shootings, judges are likely to be receptive to that, you know.
And the fact that he had access, because Dad admitted he had guns at
Access to weapons, yeah, yeah. That makes the case. That's a good example of something that would make the case. But it's pretty rare, all right? It's pretty rare. So that's an expedited hearing. It's used rarely. You have to have a situation involving behavior that's a manifestation of disability, no parental agreement, no special circumstances. So I'm going to remember that. I'm going to use that the next time I talk about this. Well, what about the kid that's posting a lot of stuff on social media? And we have reason to think they have the means and possibly the will to carry it out. Okay, so we talked about 5 already, so we're going to jump forward to 6. So this is just a good old-fashioned disciplinary change of placement, okay? So this is the consequence that the general ed student would have for the same type of behavior. Your code of conduct says you shall not steal, you shall not assault, you shall not sexually harass, you shall not bully. It's got all that stuff in there, and the students who violate that are subject to some negative consequences. Well, that's what Tool 6 is. And this is where we make a manifestation determination. And if the case conference committee says that the behavior is not a manifestation, then the student is subject to the same consequence as the general education student. So there's no 45-day cap on this, okay? The only cap is your school policy. So for example, I'll bet that your school policy calls for a year-long removal of students who bring a firearm to school. I'm pretty sure it says that because that's required by federal law. Well, that's way more than 45 school days. Can you do that with a student with a disability? Yes, if the behavior is not a manifestation of disability. And possession of a gun usually is not, okay? So, and the same consequence. That means that if the general ed student would be removed from the volleyball team, the special ed student can be removed from the volleyball team. If it's a senior, and the rule is if you do certain things, you don't get to walk at graduation. I don't know if that's a big deal in Indiana, but that's a big deal in Texas. We are always defending emergency TROs right before graduation because grandma's just flown in from Alabama and she wants to see Billy Boy walk. So the big fight's over walking. But you know, that's the last tool you guys hold over the seniors. That's it. You're losing your leverage with those seniors. So same consequence, okay? But here's the difference. If it's a student with a disability, does Indiana permit genuine expulsion of non-disabled students where they're really completely cut off from school, at least for a period of time? Do y'all permit that? It's not permitted? Okay. You're saying it is?
Gen ed student.
Gen ed student. Gen ed student.
Gen ed student.
Right.
Yes, we can spell it.
It is permitted. Okay. All right. Well, states can permit that, and but you can't do that with the special ed student because federal law says that whatever you do, the student must still have an opportunity, and here's the standard, to continue to participate in the general curriculum and to progress toward meeting the goals in the IEP. That's not exactly as saying it has to be free, appropriate public education, but it's so close that I don't make any distinction. Some people call that FAPE light because it just says progress toward meeting the goals. You know, the point is you have an ongoing responsibility to continue to serve the student appropriately. So there's no expulsion to the street for the student with a disability.
I have a question.
Yeah.
What about the student that's incarcerated?
Incarcerated? There's still a responsibility to serve students that are incarcerated. It's pretty complicated, and you're testing my memory now, because some of it has to do, we're talking about minors, right? We're not talking about adult students. And we're talking about students who were in special ed before they got incarcerated. The school district needs to work with the law enforcement officials to figure out how we're going to continue to serve that student. And you're talking about students who are incarcerated for a lengthy period of time,
Yes.
right? Okay, not just the 3 days in detention.
No.
Yeah, They're going to be there for a while. Yeah, the local school needs to talk to the local police authorities and figure out. But there is still a responsibility to continue to serve the student.
Because we're getting a lot of teenagers now.
Uh-huh.
Who are shooting and
Yeah.
doing things, a lot
Yeah.
of special needs.
Yeah, yeah. This requires a good deal of cooperation and coordination. But you know, if the law enforcement authorities are saying, "Well, no, you can't do anything," we need to have a talk. We need to have a talk because somebody's got to figure out a way to continue to serve the student. Now, how are you going to do that? I don't know. But your superintendent should be in touch with the mayor or the chief of police or whoever it is they need to talk about and work it out at that level. A lot of places have an MOU, a memorandum of understanding, that kind of lays out how this is going to work. Saw a hand up back there.
When students are in jail, I'm not positive of the things, but when students are sentenced to the Department of Corrections in the state of Indiana, the Department of Corrections has a team of educators that takes care of the special
They do that.
education.
Okay.
So
Yeah, I'm not saying it necessarily has to be the local school, but somebody's got to figure it out because they're still eligible for appropriate services. And there's a lot of ways to do that. Okay? Yes, ma'am.
So what happens to the diploma track special education student senior that's 18 or 19? I've heard two attorneys say you're dealing with minors, you're dealing with minors.
What if we're not dealing with minors?
Yeah,
What if they're 18?
I mean, they're legitimately in school, they are legitimately special ed students, they're legitimately diploma track.
Right.
What happened? So.
And you're talking about and they get incarcerated?
No,
No.
I'm just saying, like, how is it, everything I've heard so far is according to the minors. So they're they still have the same rights in the school, it's
Yeah.
just been transferred to them.
Yes.
Got it.
Yeah.
Okay.
Yeah, they haven't graduated, right?
Right.
You said they have not graduated. We're not done with them.
So these still apply,
Yes.
they're just responsible.
It's just that they're the ones that are,
Got it.
the school needs to work with them, not the
Not the
parent.
parent.
Yeah,
Okay,
exactly.
sorry.
And that doesn't mean the parent has to be excluded. You know, a lot of that's going to depend on the relationship between the student and the parent. Because I remember I read some case recently, I think it was in my handout this morning, it was one of the cases we skipped over, but there's one case in there where the student had turned 18 and the parent requested the due process hearing. And the hearing officer dismissed it. Now, the student could have authorized the parent to act on my behalf. The student could have executed a simple power of attorney. I want my dad to have this authority, or my mom, but the student didn't do it. And so the hearing officer, I think, correctly said, parents, you have no standing, is the legal term. You have no standing at this point. Yeah, it has to be the student. So that's how that works. Okay?
Can I ask a question related to expedited hearing?
Related to what?
The expedited.
Expedited hearing? Okay.
Does that trigger an expedited eval?
No.
No, okay,
The only time, no. Mm-mm.
okay.
There's a provision for an expedited eval if we are in the process of disciplining a student, general ed student, and that's when the parent requests an evaluation. And that should be expedited, okay? But no, the expedited hearing has nothing to do with that. Okay, good questions. So the only other thing I'll say about disciplinary change of placement, I'm not sure how you guys do it. I'll tell you what I recommend. Do the general ed due process piece first, then do the case conference committee. In other words, the first issue should be, did the student violate the code of conduct? Because there may be a genuine dispute over that. You know, students can argue, oh, well, yeah, I hit that other kid, but, you know, I've been bullied for the last 6 months. Yeah, I hit that other kid, but it was self-defense. Have you heard Hodgins's take on self-defense? It's hilarious. I don't know if he did that here, but he's done it before. So there may be a legitimate thing. You know, yes, you caught me with, yes, there was beer in the car, but it's my dad's. He left it there and I didn't know it was there. So all of these things are legitimate things. You know, I thought it was oregano. I didn't know it was marijuana. I didn't know what was in my backpack. You know, maybe the student's lying, maybe the student isn't. But those are all legitimate things, but they have nothing to do with the disability. So let's deal with that first. Let's have the hearing. Let's give the student notice of the charges and an opportunity to give their side of the story, and then let's take action on that basis. And so typically that's done by a campus administrator, principal, assistant principal. And then if they conclude, yes, this student violated the code of conduct, well then the next issue is, did it have anything to do with disability? So let's take that to the case conference committee. So my recommendation would be go through the regular ed due process first, just as you would with a non-disabled student, then take it to the case conference committee, because by that time we've already established the student has violated the code of conduct. Parents still might disagree with it, but we've made a ruling on that. So that's a fact, all right? And then we take that to the case conference committee. Okay, I got you. Did I get you guys to say this morning? I don't think I did. I think we said respondeat et superior as a group, didn't we? Yes. We didn't do this. So we need to do this. Vape-free zone on the count of 3. With enthusiasm, 1, 2, 3.
Vape-free zone.
Very good. Okay. Yes, ma'am.
In my area, what we just talked about, what I see happening is we do the manifestation, we determine if it is or is not a manifestation. If they say it's not, then they do the expulsion hearing.
Well, you can do it that way. I think it makes more sense to do it the other way.
The other way, you're already saying that they did it.
You said they did it.
They're making that decision.
Right.
And nobody's decided whether they actually did.
Yeah, but to me, whether they did it is the more fundamental issue. And furthermore, making that decision and hearing both sides of the story helps you make a good manifestation determination. You know, we've heard all sides of this story. We're not jumping to a conclusion. I think it helps you make a better decision. So, you know, I came to this conclusion a long time ago. I was in a bizarre IEP meeting. It was a kid who burned the school down to the ground. I mean, I don't think he intended to do that. I think he I do think he intended to start a fire. I don't think he had any idea how quickly it was going to get out of control. It turned out to be a really big deal. And his parents' contention was he didn't start the fire, you know? Well, you know, we didn't have a video. We didn't know for certain that he did it. There was a lot of evidence pointing to him. I believe he did it. But this school district did it the way you said. They had the IEP meeting first. And it was just bizarre. We're talking to the parents. We said, well, you know, you say Ronnie didn't start the fire. We understand that's your position, and we'll deal with that later. But let's just say he did start the fire. Do you think it had anything to do with his learning disability in mathematics? And they looked at us like, what are you talking about? I was very grateful that the parents had a lawyer, because lawyers can compartmentalize stuff like this, you know. And so the lawyer advised the parents and said, well, it's just a hypothetical question. You know, if he had started the fire, do you think it had anything to do with disability? Well, no. But he didn't start the fire. Well, we know. So I just decided we ain't doing this again. You know, we're going to have the general ed hearing first and deal with all of that. Who started the fire, to quote Billy Joel. And then we'll deal with the other, okay? So here's your vape-free zone. These are the 10 days. And the Supreme Court affirmed this. The Supreme Court has only had one case that deals with special ed discipline in the, what was it, since 1975? How many years is it now? 46 years of special ed law. One case involving special ed discipline has gone to the Supreme Court. And in that case, this wasn't the issue, but in the process of deciding the case, the Supreme Court said, schools are not powerless, they have 10 days. And so they kind of gave their blessing to this 10-day thing. Now I call it vape-free because the school is not obligated to provide any services at all, as long as the general ed student would receive no services at all. I think in most states, when a principal orders a 3-day out-of-school suspension, there is no service to be provided during that time. And so if that's how you handle the general ed student, that's how you can handle the special ed student, as long as you're within the vape-free zone. So we got to count our days. We have to know what days we count. So once the 10 days are gone, it's over until next school year. It's like your birthday. It happens once a year, okay? So what days do we count? Now, I'll tell you, I'm confident that any out-of-school suspension counts, regardless of the creative name that you may come up with for it. I've heard therapeutic intervention. I've heard cooling off period. I've heard administrative leave. You know, administrative leave is what you do for an assistant principal who's hitting on the high school girls. That's what administrative leave is. So that's not this. And here's my favorite. Did you suspend the student? No, we never suspend the student. We did call the parents and say, come get them. Parents, come get them. That's a suspension, okay? So if you have removed the student for disciplinary reasons, that's a day. You got to count that. Now what's confusing is in-school suspensions. You all have in-school suspension? Okay. ISS is confusing. I call it the dreaded ISS question. If we send the student to in-school suspension for 3 days, do we have to count that toward the 10? And I wish I could tell you that the law on that is crystal clear. It is not, okay? So this is something you need to talk about. And you may want to bring in your school district's attorney and have a discussion about this, because there's pros and cons. If you count the time they spend in ISS toward 10, you're going to get to 10 faster. If you don't count the 10, then you may end up having the student spend a good bit of time in in-school suspension thinking that everything is okay, and end up in a hearing with the parent a year later and having some hearing officer say, what you really did was you changed the child's placement without having a case conference committee. That's illegal. So there's pros and cons, okay? Now the only thing we have on ISS is kind of informal guidance from the Department of Education. It doesn't carry a lot of weight. But they say there's three factors, okay? So as to whether ISS counts. Factor number 1, does the student still have access to the general curriculum? In other words, when the student is in ISS, what's the student doing? Is the student doing work related to the classes the student is currently enrolled in? Is the student getting credit for those classes? Does the student have access to a teacher? That's factor number 1. Factor number 2, are you still completely implementing the IEP with fidelity? You know, when the student goes to ISS, do you still provide the speech therapy that the student is supposed to get? Are you still providing the special transportation, counseling, BIP, etc.? Let me finish with this, then I'll take your question. So most districts that have an ISS program, they do pretty well with those first 2 factors. The problem is the third factor. Whoever wrote the third factor doesn't understand what ISS is all about. Here's the third factor. The student continues to interact with non-disabled peers to the extent that they would have in their current placement. Did you hear that last part? To the extent they would have in their current placement. That ain't ISS, okay? If they put a period after the student will interact with non-disabled peers, if the period was right there, then it would be easy. You just need to be sure there's some general ed kids in ISS. And if you don't have any, go find some. Somebody's doing something that deserves ISS, you know? Just walk around the building for a while. Find some kid doing something wrong. You, are you in special ed? No, sir. Go to ISS. Why? We need you there, you know? Don't ask questions, just go. So, you know, this is something, unfortunately, no lawyer that I know of can give you a crystal clear answer. ISS counts, ISS doesn't count. There's pros and cons. Talk it over. Okay, question?
So, my question is just like let's say we have a student who does their English and their math in the special ed classroom so many minutes a week, but they're in school suspension, so they didn't get those minutes. But how do you determine when they got those minutes if there's not in that study?
Yeah, well, I don't read this commentary to the regulations to mean that you have exactly replicate things exactly as they were. There's different ways to do it. For example, one thing about ISS is it's usually just a few handful of students that are in there. And so there is an opportunity to have more direct interaction and maybe move faster on things than we would in another classroom. So I don't know. Those are good questions, but I don't think it's a minute-for-minute match that you have to do. But I do think you have to be able to say, we're still providing all the related services, and we're providing an opportunity to progress on the IEP goals, okay? Okay, so let's go into tool number 8. Getting a little, we got about 15 minutes left here. Yeah. So I told you this is where it gets confusing, right? So are you all okay? Does anybody need to stand up and stretch and wake up? Are you all right? Because you need to be cognitively alert for tool number 8, because this is the most complicated. And I will tell you, this is one of the main reasons I created the toolbox. And that's because principals kept asking me these difficult questions. Do I get another 10 days? No. What happens after the 10 days? One principal said, can we create a FAPE-free zone bank? So what do you mean a bank? He said, well, you know, like our sick leave bank. You know, we have kids that never use up their FAPE-free zone. You know, they're just so well behaved. And we got other kids that need more days. Can't we just, you know, transfer them on the books? No, I don't think so. Can't do that. So I was getting all these questions, and here's where it really came to a head. There were a couple of instances where a student had committed unquestionably a serious violation of the code of conduct. Let's say they physically assaulted a teacher. I think we would all agree that's a pretty serious violation of the code of conduct. The FAPE-free days have already been used up, all right? What are we going to do? Well, if it's a physical assault of a teacher, we're probably going to file criminal charges. That's tool number 10. That's available. But more often than not, charges are filed and the student is immediately released. All right? So what are we going to do? We're going to send the student home? Well, we can't do that because we've already used our 10 days. Are we going to just put the student right back in the classroom with the teacher that he just assaulted? That ain't going to go over too well with the teachers' union. I love being able to say those words. We don't have teacher unions. You guys do, don't you? We don't have that. Anyway, that won't go over too well in the teacher's lounge, my experience. You know, the student who physically assaulted the student, teachers expect to not see that student for a little while. So what are we going to do? What are we going to do? And here's what I kept hearing from principals. We're going to have that IEP team meeting tomorrow. Why? Because we need to do the manifestation right now. Because we can't move the student until we do the manifestation. This was the thinking. So I started examining that. Is that really accurate? And I came to the conclusion it is not accurate and it is dangerous. Because if you rush into the manifestation determination, you're potentially violating the parent's rights. The parent is entitled to written notice of the case conference committee a reasonable amount of time. Telling the parent we're having the meeting tomorrow is usually not a reasonable amount of time. Again, this is one of those circumstances where you have to give the parent the procedural safeguards document. Why do we have to do that? Because so much of that document is about this very thing, long-term discipline. So we want the parent to be able to read the rules and understand it before the parent comes to the case conference committee. So if you rush the parent into that, and you know, in Texas a lot of parents sign a waiver. But you can't count on that. And the school should never try to slip that past an unsophisticated parent. So that's one problem with the hurry up IEP meeting. The second problem is you're rushing the staff into making a complicated decision in a hurry. To do a manifestation properly, you've got to gather a lot of information. You've got to get a group of people together. You've got to make sure you have a firm foundation for your decision. We need some time to do that. So I came to the conclusion that in that scenario, we'd be better off if we didn't rush into the case conference committee. We'd be better off if we could buy ourselves some time. But what are we going to do with the student? So that's where tool number 8 comes in, okay? So do I get another 10 days? Well, my short answer to that is yes. It's just that they're not FAPE-free. This is why I like the term FAPE-free zone. It draws a distinction between the first 10 days and everything that happens after that. Do principals still have authority to order a short removal of the student? Yes, they do. But they're not FAPE-free days. So what does that mean? We also have to be sure we don't overuse this tool. If we use it cumulatively too often, it creates another change of placement. Now this is where I really need the whole day presentation to go through all of that in detail, but just keep that in mind. And remember, just because you can use another 10 days doesn't mean it's a good idea. You know, if the student's already used up the FAPE-free zone and the student's committed a serious violation of the code of conduct, I'd call for an IEP meeting anyway. I mean, you have to have one because you're going to have to do a manifestation. So when would it be wise? Well, this is, I just kind of laid this out. I think I have an example here. Let's see, do I have it? Yeah, here's the hypothetical. October 6th, the student assaults a teacher. Student didn't use a weapon. Teacher was not seriously hurt. So what does that tell us? What tool have we just eliminated there? Tool 5, right. Good for you, you had it. I always look, people don't know, I got the numbers so internal, but that is tool 5, good for you. Yeah, we can't use tool 5 because there was no weapon, there was no serious injury. What's the deadline for the manifestation? It's October 20th. How do I know that? Federal law says 10 school days, all right? 10 school days is 14 calendar days. 6 plus 14, 20. So we don't need to have the case conference committee until October 20th. Now, a principal might want to have it like right now, but I think that's faulty thinking. The FAPE-free days are gone. What are we going to do with the student? District has to serve the student. Why? Because the FAPE-free days are gone. The student can remain in the IEP placement, but that might not be a good idea. But so here's tool 8. Tool 8 is the principal assigns the student to an interim setting for the days leading up to the IEP team meeting, okay? So I like to use the word assign to distinguish it from place. Who places kids? Case conference committee. Principals don't place. So they shouldn't say, I'm placing your student here. But the principal can say, I am assigning your student to an interim setting for 6 days, 7 days, 8 days, all the way up to 10 days, just until we have a case conference committee to discuss what we're going to do in the long term. Can principals really do that? Well, here's the authority. I'm going to show you a direct quote from the federal regulations. And this is one regulation that encompasses what I call Tool 7 and Tool 8. Remember Tool 7, FAPE-free zone? Tool 8 is what you do short term after the FAPE-free zone. Here's what it says about Tool 7. School personnel may remove a child with a disability who violates a code of student conduct for not more than 10 consecutive school days. Okay? Now that's the FAPE-free zone. And so I call that Tool 7. Whoops, why is it not? And here's the rest of it. That very same regulation goes on to say, and for additional removals. In other words, school personnel can additionally remove the student for not more than 10 days in the same school year for a separate incident of misconduct, as long as it doesn't create a change of placement. Okay? So do I get another 10 days? I think it's very clear from that. Why would they use additional days of removal? New incident, same school year. So we're clearly authorized to go beyond 10, all right? But they're not FAPE-free. And here's why we know they're not FAPE-free, because the regulation goes on to say this. Now, you know, I kind of wish I'd cut this in two, because I'm going to ask you to stop midway through here. But after a child with a disability has been removed from the current placement for 10 school days in the same school year. Well, you all pause right there. Don't look at the rest of it. Just pause right there after a year. If we were putting this in Toolbox terminology, you know what that would say? After a child has been removed from the current placement for 10 school days in the same school year, we would say after the FAPE-free zone. Do you see that? This is where I'm trying to simplify things for us. After the FAPE-free zone, if there's a subsequent removal, doesn't that tell us there can be a subsequent removal? Why would they be talking about subsequent removals if it's prohibited? It's not. During any subsequent removals, we have to provide services. Oh, there's the difference. FAPE-free zone, no services. After the FAPE-free zone, you can move the kid to a different setting, but you got to figure out a way to serve them. Okay? So that's the distinction. So what do I do as principal? Let me go back to my hypothetical. All right, students assaulted a teacher. I called the cops. Students coming back to school the next day. I need to contact special ed department immediately. They need to set up a case conference committee. They need to give notice to the parent. They need to give the parents the procedural safeguards document. We got a lot of work to do. I need to get my special ed staff working on preparing for the manifestation determination. Meanwhile, we have to have a hearing for the student to determine, did he really assault the teacher? Was there any justification for it? Did he commit this offense? We got to do all that. What am I going to do with the student? The cops, it's catch and release week at the police department. They charged him, he's released, he's right back on campus. What are we going to do? I assign him somewhere. Where? Well, I don't know, but it's got to be an interim alternative setting. Might it be in-school suspension? Might be. But it's got to be something where the student is under our supervision and receiving services. Okay? So that's how that works. That's Tool 8. Okay? All right, so I'm going to finish up here, and then we'll see if you guys have some questions. And we went through all this. All right, leadership at the IEP meeting. It is warm. I'm going to take my jacket off here. Are you guys warm? No? Who's too hot? Who's too cold? It should balance out, you know, usually. Is everybody just hunky-dory, just right? That's never happened. We used to put on these statewide conferences, and we'd always separate the evaluations into the people who said the room was too cold and the people who said the room was too hot. We figured if we got about an equal number, then we must have done it just right. Leadership at the meeting. You know, that's always needed, but particularly when the team is not going to come to consensus. And so again, I would encourage you to ask yourself the 3 questions. Is this worth fighting over? Are we legally defensible? And are we united? Now, you know, there's only 2 parties at an IEP meeting, at a case conference committee. You guys might have a dozen people sitting around the table, but there's only 2 parties. There is the school and there's the parent, or the school and the 18-year-old student. So there's only two parties. That means you have the possibility for a tie vote, so to speak, you know, because the school ultimately has to speak with a united voice. Now, there's frequently disagreements among the school people about what to do. That happens all the time. And that should not be something you're afraid of. That is part and parcel of that's why we have multiple people at the IEP meetings, so that we can get different perspectives. But we've got to somehow come to consensus. And I really view that as the leadership role of the person who serves as the administrative representative, trying to synthesize what the team seems to believe and giving voice to it. So if I'm the leader of the meeting, it's more important that I listen to my staff than I talk. I'm not the quarterback. I'm not dictating the play. But I want to listen to the staff and see if I can put it into consensus and say to the parent, well, this is where we stand. This is what we're going to put in the IEP. Let's see if you agree or you disagree. You know, the other thing is I try to emphasize about case conference committees is it is not the students' meeting. If you ask your teachers whose meeting is it, teachers are warm-hearted, gooey people. Well, that's what they look like. But you ask them whose meeting is it, and most of them will say, well, it's the child's meeting. Well, it's not the child's meeting. It's about the child, but it's the school's meeting. How do I know that? It's the school's meeting because the federal law says so. The federal law says the school district is responsible for initiating and conducting these meetings. If the meeting doesn't happen on time every year, whose fault is that? The school. So it's our meeting. That means the school should control the meeting, all right? And I mean no disrespect to parents on that, but the parents are invited. They're invited to be a meaningful participant, but it is the school's meeting. So the school should control it. That doesn't mean they control the outcome. It means they control the process. I'm a big believer in somebody standing up. You notice there's only one person, well, this guy's standing up, but that's because he's operating the camera. But I'm standing up because I am the leader of this meeting. So sometimes you need to get vertical in an IEP meeting. It's a simple way to say, I'm seizing control. It's okay for the school to control the process, all right? The way we do it, the agenda, the timing. You know, I'm for at the beginning of the meeting saying, let's talk about how long we're going to be here. Have you all ever had interminable case conference committee meetings? Anybody know what the statewide record is? Longest meeting? You've had a lot of.
Oh, I had one that lasted 7.5 hours.
7.5 hours.
Started at 8:30 and ended at 3:30.
Yeah. Did you have pizza?
No.
You had to have some sustenance there.
We actually went straight through. I'll never do that again.
Oh, no. You're not going to come up with a good IEP.
But at the time, my director said, don't come back without a signed IEP.
Yeah,
And so
all
I
right.
was afraid to go back to work.
So it's like the union negotiators locked into we're not letting you out until you have an agreement. Yeah. I think that's an abuse of the process. And because 3 days. I mean, we did go home and sleep, right?
Yeah.
Okay, but 3 days. Did you come to consensus after all that time?
Yes, we did.
We did. Did it stick?
No.
No. Yeah. So you didn't really come to consensus.
People went to another state.
Yeah. So, you know, here's what the regulations say. The regulations say that the meeting is supposed to be at a mutually agreeable time and place. I think that mutually agreeable should apply to the beginning as well as the end of the meeting. So I think it's perfectly respectful to start the meeting by saying, you know, I think we can get our business done in about 2 hours here. What do you think, parent? Are you on board with that? Let's see if we can have an agreement on this. I think we can get done in 2 hours. And, you know, there's two steps toward getting agreement on a ground rule. The first is to check for understanding. You look around the room and you say, I'm proposing that we commit to a 2-hour meeting. Does everybody agree with that? Or does everybody understand that? Yeah, okay. And then I check for agreement. Well, are you on board with that? Do you think we can get our business done in 2 hours? And if everybody says, yeah, I think we can do that, then you got a ground rule, okay? Next ground rule. If we're going to get this done in 2 hours, I'm going to ask everybody to put away the homework papers that they're grading, and I'm going to even ask you to put away your device. Ooh, put away your device there, broken nose. So I saw her, she was just, it's like I was picking on her, like she put the device away. I'm going to ask everybody to put their device away so that we can get done in 2 hours. So, you know, stuff like that. That's what I mean by controlling the process. You're not controlling the outcome. You're not dictating the content of the IEP. The IEP is a continual process of we propose, and the parent responds, or the parent requests and we respond. It's a dance, okay? So it's a tie vote. So the best metaphor for case conference committees is marriage, because there's two parties in a marriage, right? There might be multiple people. I harbor millions within me, and my wife is more complicated than I am, but there's only two parties, and we have to figure out a way to come to consensus. So that's what we're doing here, okay? So I think we did all that. We talked about special ed being upside down. Okay, I don't have too much to say about calling the cops. You can do it. Any questions? It's obviously not something we want to do, and my main advice to people about calling in law enforcement is just be sure you're even-handed about this. If we call the police for certain types of offenses, let's call the police, regardless whether that is what kind of a student. Let's call the police. You should have some agreements with the police as how we interact. The police, by the way, are not automatically entitled to all of the information about students. We should not be releasing confidential information to the students. They typically don't need that. Now, if they're going to take a student in custody, there might be some reason to disclose some immediate health concern that we want to be sure that the police are aware of. But general rule, you know, they have no business knowing whether the student is in special ed, what the disability is, what the IEP is like, what the discipline record is like. You might get a subpoena later for records. Okay, we'll respond to that. You might have parent consent to release records to the police. But until we get that, you know, it's a little premature. So you just got a brief overview of what's an all-day training program. Oh, I've gone past 2:15. That's why you're standing there, Elisa. I figured that out finally. So that's how that works. You know, like I said at the beginning, this is not new. The law hasn't changed since 2006, so this is not new. I've just tried to put it in a framework with a vocabulary, and I hope you find that helpful. Okay? So thanks for coming. We're going to have the panel discussion at 2:30, and I look forward to that. And thanks again to Alyssa for facilitating, and the cameraman for the excellent camera work, and we'll see you guys around. Thanks for coming.